Okay. Hi, good afternoon, everyone. Today we are glad to have our former partner Caroline Goh with us today. So for your information, she has opened her own firm. Okay, a little bit about Caroline. Caroline is qualified with LLB honours from the University of London in 2003 and called to the Malaysian Bar in 2006. She served on the Bar Council Family Law Committee as well as Industrial and Employment Law Committee. She has vast experience in various areas of family law, including contested divorce, guardianship and custody, legitimacy application, adoption, maintenance, and financial arrangement. So please join me to welcome our speaker, Caroline Goh.
Hi, everybody.
Hi.
Hi. How many participants we have? 11, right? 18.
Yeah, 18.
Okay. Today we are talking about the things to know about divorce. Mr. Tu is here or he's not? Don't think so, right? He's so busy. Okay. How to click to the next slide?
You click on the slide and
okay.
then
Can.
okay.
Okay. These are the list of applicable law if you are interested to know more about the divorce. Okay. I.e. the Law Reform Marriage and Divorce Act 1976. In short, we normally call LRA. Yeah, and this LRA has been amended and the amendment actually took effect in December 2018, the 15th of December. Okay. Then there are also rules that is applicable to divorce law, Divorce and Matrimonial Proceedings Rules 1980. Okay, then Guardianship of Infants Act 1961, Married Women and Children Maintenance Act 1950, and also the Married Women and Children Enforcement of Maintenance Act 1968. If you have time, you may actually go to those online library to look for these acts. Yeah. Okay, then who can apply for divorce under LRA? Generally, all persons in Malaysia who domicile in Malaysia. Okay, Section 48 provides for that. Then all Malaysians who resident outside Malaysia. Of course, this legislation, the LRA, doesn't apply to Muslim or those married under Islamic law. But do take note there is this new amendment to the LRA. Yeah. Let me close this. Okay, the court actually has exclusive jurisdiction to hear and make orders against the converted spouse. That was in effect, like I mentioned earlier, the 15 December 2018. Previously, it's very uncertain, and most often than not, the court will say they have no jurisdiction to hear or make orders against the converted spouse. Yeah, those spouses converted into Islam. They will say the court who make orders under this LRA is not applicable to them. They are not bound. Okay, the LRA, there is some exception as well. The native of Sabah or Sarawak or any aborigine of West Malaysia, the marriage and divorce is governed by their native customary law or aboriginal custom. Okay, you can look at section 3. Do take note, in Malaysia, a Malaysian wife is incapable of acquiring independent domicile while she remains married. Because in the LRA, for you to apply for the divorce, the parties must be having their place of domicile in Malaysia. Okay. What if a foreign husband has deserted a Malaysian wife and nowhere to be found? Can she still file for divorce in Malaysia? It's a bit weird, right? Talking to our own screen. Anyone has any idea or have the answer to this question? I guess you are shaking your head now. Oh, no one, is it? Okay, I guess it's a no. Okay, actually there is a avenue for those foreigner wife and also the foreign husband, the wife who has a foreign husband. Okay, they can actually file for divorce under section 48 of the LRA. Okay, that actually says, I'm not sure whether any one of you are holding the LRA now. Okay, the section 49, sorry, not 48. The 49 actually provides the additional jurisdiction in proceedings by a wife. That means if the wife is married to a foreign husband in Malaysia, because in Malaysia, the wife actually follow the husband's domicile, you see. So if they want a divorce, their foreign husband is not in Malaysia anymore, they can still file divorce. Yeah, the provision can be found in section 49. Okay, but of course there is some terms and conditions, because it says that the wife must be a resident in Malaysia and has been a resident in Malaysia for a period of 2 years before they file the divorce. Okay, so do look at the section 49 when you have time. Okay, next slide. There are basically 3 types of divorce proceedings in Malaysia. The number 1 would be the dissolution of marriage, where either spouse has converted to Islam. Is in section 51. Then either party and both parties may petition for divorce. This is a new law. Previously, only the non-converted spouse can file, but now either party, and if they want to file for the joint petition, which we'll talk about in paragraph 2, both parties can also file for joint petition for divorce. Okay, then section 50, if a party is filing this divorce under conversion ground, then section 50 is not applicable to section 51. That means the 2 years restriction period is not applicable to those who want to file divorce under section 51, i.e. their spouse has been converted to Islam. Okay, then dissolution of marriage, number 2, by mutual consent, which I just mentioned a moment ago, joint petition. You can find that in section 52. Okay, the prerequisite, of course, both spouses must mutually agree and freely consent to all the terms stated in their joint petition for divorce. Okay, for this option, is lesser documents to be prepared by lawyer, and it will be faster and lower cost. Okay, but do take note of the MCO now. There is a SOP. So the faster may mean a bit longer than previous before pre-MCO period. Okay, number 3, the third type would be the dissolution of marriage, where either spouse claims the marriage has irreparably broken down. That means it's by way of single, or we call unilateral petition. It's under section 53. Okay, for those who cannot get consent from their spouse, then they can actually file divorce under section 53. Of course, they need to satisfy the court any ground that is provided in section 54, i.e. Adultery, unreasonable behavior, 2 years of desertion, and 2 years of separation. Either one ground will do. Okay, in the event it's being challenged, then the spouse who filed the divorce petition must prove. Okay, and before the party who filed this single petition, they must first obtain a certificate from the conciliatory body, or we also commonly call marriage tribunal. It's actually a department in JPN where you do your IC, or where you register your marriage. Okay, unless you seek leave for dispensation from court, and if it's obtained. You can find that in section 106. Okay, in terms of this type of single petition, there are more documents to be prepared, and it's definitely lengthier because it depends on whether your other spouse is challenging the process. Okay, and of course, the cost will be higher. That means the spouse will incur more legal costs. Okay, and okay, there is a question that I posed here. Can a husband wife sign the JP but say no in court later? Okay, cannot see a show of hands here. Okay, I will answer myself. Okay, can a husband wife sign the JP but say no in court? Is it like a contract or not, the JP? Unfortunately, it's not. If you are the one who wanted divorce so much, and you're so happy that your spouse has already signed the JP, but he turned up in court and say no, then your lawyer will have to withdraw the JP on your behalf because there is no mutual consent when the parties appear in court and say no in front of the judge. The judge must be actually fully satisfied that the parties fully consent and agree with all the terms. When one party turn out in court and say no, the whole JP will become redundant. Okay, your lawyer will have no choice but to withdraw. Or your lawyer can also opt to stand out, maybe adjourn the hearing of your JP. Okay, maybe seek a short date to see what are the issues raised by the other party when he says no in court or when she says no in court. Okay, try to see whether you can still continue. Yeah, but if, of course, if both parties would like to continue their marriage, I believe it should be a happy ending because no one would actually want somebody's marriage to be dissolved unless there are many there are some grounds that the party cannot stand with the other party, like for example there is domestic violence. Yeah, then this kind of violent act cannot be tolerated. Okay, next would be where to file divorce petition. Okay, a divorce petition can only be filed in High Court. Okay, cannot be filed in Magistrates Court or Sessions Court. Okay, which High Court? Because in Malaysia, I think we have quite a number of High Courts, like High Court in Shah Alam, KL High Court, Kuantan High Court, and so on and so forth. Okay, you file in the High Court where you or your spouse resides. Okay, let's say if you stay in KL, you can't really file in Johor Bahru, okay, unless your spouse stay there. Then you can use the address of your spouse. Okay, there is this quite recent direction from the judiciary, with effect from the 1st of July 2020. Specified Sessions Court judge have been conferred with jurisdiction to hear the cases under LRA. Okay, it's not the Sessions Court being conferred with this power. It's actually certain Sessions Court judges only. Okay, so you may want to find out whether in that particular state, whether there are any Sessions Court judges are conferred with those power to hear the LRA matters. Okay, okay, when to file divorce petition? Generally, I also mentioned this just now, no one can actually petition for divorce within 2 years from the date of their marriage, okay, unless you can show exceptional case or hardship suffered. Okay, you can see this under section 50. Okay, of course, there is also another exception, section 51. Remember earlier I said section 51, this section 50 doesn't apply to section 51 where the divorce is actually grounded on conversion to Islam of one spouse. Okay, leave application must be made if to divorce within the restricted period of that 2 years. Okay, you must seek leave. Okay, then you prove the exceptional case or hardship that you have suffered. Okay, The court shall consider the interests of any children and any possibility of reconciliation in such leave application. Okay, if there is children and their hardship that you intended to show in court cannot actually convince the court, then you may not get your leave. Is it the end of the matter? No, you can still divorce after the 2 years restriction period. Okay. These are the issues to be considered before divorce. So if you are a lawyer or you have your clients who come to you and ask you what they have to do when they wanted to divorce, then these are the issues that you need to advise them. Okay, for the children, guardianship, custody, care, and control of children need to be considered by the parties. Is under section 88 and 89 of the LRA. Then there are also visitation access rights under section 89. Okay, we will elaborate a little bit more later. Okay, maintenance for children as well need to be considered by the parties. And for this, the duty to maintain the kid, the duty has been extended. Okay, we will discuss this later. Okay, for the wife or the husband, there is this issue of spousal maintenance under section 77. Then division of matrimonial assets under section 76. Okay, there is this new factor to be considered by the court, which is the duration of marriage. Is the factor to be considered when deciding the division of matrimonial assets between the parties. Okay. My speaker is loud enough, right?
Yeah, clear.
Okay, good. Okay, then there is this also issue of injunction against molestation. Domestic violence is under section 103. Okay. The first issue that we touched on earlier, the guardianship versus custody. Okay, the guardianship actually means a parent has the responsibility for a child's long-term welfare. That will include the parents' involvement in the major decisions such as the child's health, education, where they would have a better chance to study, and religion. And unless a court orders otherwise, both parents are actually joint guardians of a child by virtue of the Guardianship of Infants Act 1961. Okay, an order for custody for a child in the family court gives the custodial parent the right to have the daily care and control and to upbring the child, and also the right and responsibility to make decisions about such daily care and control. Okay, custody order ceases to have effect when a child turns 18 years of age. Of course, take note of the new amendment. Okay, the custody of a child will remain with the parent if the child still continue to pursue training or their education. Okay, custody, care, and control versus visitation access rights. Okay, when the court placed the custody with either parent, then the main consideration, which is the paramount consideration, is the welfare of the child. Yeah, that means what is in the best interest of a child for the court to place his custody with either the mother or the father. Okay, the court will consider the wishes of the parents. Okay, I don't think the court would actually place the custody of a child with the parent who actually doesn't want to take up their responsibility. Okay, so wishes of the parents will be considered. Then the wishes of the child, where the child is of an age to express an independent opinion, then the child will also speak to the child. The court will also speak to the child, sorry. Okay, normally we call the child interview. That will be done in the judge's chambers. If the court find that it's good to have the interview with the kid before before the court decides on the custody to be granted to which parent. Okay, and there is this presumption, rebuttable presumption. That means a child will always be deemed to be better or good to be with the mother, okay, when the child is below the 7 years old. Okay, of course, nowadays, this presumption can be easily rebutted. Okay, because previously, like my time when I was small, I believed the mother would be the full-time housewife. But nowadays, both parents are working parents. So it may not be that good. That presumption may not apply to a mother who is a working mother. Okay, of course, all that depends on case-to-case basis. Okay, and each child will be considered separately. If there are siblings in a marriage, then the child will consider them separately. Okay, it doesn't mean that if the elder brother is granted the custody of that elder brother is granted to the mother, then the younger sister will be also given to the mother. It depends. Okay, then non-custodial parents shall have visitation access rights to their children. Okay, this means whoever is not given the custody, the daily care, the caretaker, okay, the daily caretaker, then the other parent will be given the right to see their children. It's actually the right of the kid to see their parent, whoever is not staying with them every day. Okay, this is what we call visitation access right. It's under section 89 sub 2. Okay, and normally we will hear this question: can a non-working mother apply for custody maintenance of her children? Okay, I've had clients that come to me and ask, I'm not working. I used to work, but after I married to my husband, then I quit my job and be a full-time housewife. Can I still apply for my custody because I want to divorce my husband? Answer is yes. Yeah, because if you look at the provision in LRA, it doesn't say that the prerequisite, the precondition precedent of divorce or custody for or maintenance for the children is only for working mother or working parent. It doesn't say so. Okay, so if you have a friend that unfortunately have to come to this stage to apply for divorce and she's not working, and tell her she doesn't have to worry, she can apply for custody of their children. Okay, of course, for her to take care, and before she can actually get a job to take care of her children, she can always apply for maintenance in court against the husband to pay. Okay, and how are the visitation access rights like? It again depends on the facts of your client's case. Or some they actually want it's like a timetable for the non-custodial parent to have the right to see their kid. It depends on the party's timetable. Generally, or more commonly, we will have like alternate weekend access from Friday night until Sunday evening. Yeah, why alternate? Because the other parent who has the custody of the kid may have to work as well. So the rest of the alternate weekend the children can actually stay with her. Okay, this is the purpose of the alternate weekend. Like another example of having access would be like school holidays. Yeah, the non-custodial parent can actually ask for half of the school holidays of their children to be given to them. Like Mother's Day, if the non-custodial parent is a mother. Yeah. Of course, similarly, if the non-custodial parent is the father, he can also ask like his birthday, he would like to see the children, then the access should be given to him during his birthday annually. Then what about if it comes to the children's birthday? Okay, then normally we will advise client alternate children's birthday. This year is for the father, then next year for the mother. Okay, something like that. Okay, then next question is divorce a prerequisite in application for children custody maintenance? Answer is no. Okay, Parties can always apply for children custody and also their maintenance in court, even they don't file for divorce. Okay, because they are like other clients who actually has their religious ground not to file divorce against their spouse, like Indian. Okay, if they don't file divorce, they can still apply for the children custody, but because they are separating for their spouse already, okay, the custody must be actually decided, otherwise there will be issues. Okay, maintenance of children. A father shall maintain his children, which include his or her daily expenses such as accommodation, food and clothing, educational and medical expenses. Father shall have the primary obligation to maintain his children, and even though the child is not in his custody. Okay, that means if he is not a non-custodial parent, he still has the obligation to maintain his children. Yeah. Okay. What is the test? How to decide the maintenance sum? Then we apply this means and needs test. Means would refer to whoever is paying the maintenance, how much he can afford to pay, and needs would apply to the kid, how much he actually is in need to maintain his daily life. Okay, normally will be the one who filed the custody for him in court to prove how much is sufficient and what are the needed and what are the requirement for the applicant, yeah, to apply in court for the maintenance sum. Okay, the court may also order a mother to contribute towards such maintenance if she is a working parent and she is earning equal like or more income than the father. Okay, so it really depends on the facts of our case. Okay, then the maintenance, this duty to maintain the kid would actually cease upon their children complete further or higher education or training. Of course, if the children are not pursuing any other education or training after 18, then this duty actually ceases when the child attains 18 years old. Okay, you can look at section 95. Okay, then you can see these areas of maintenance issues. Okay, for example, if you have client coming to ask you, she has previously obtained a maintenance order against the husband, and the sum is like going since 2015. Can she claim that against the husband or not? The answer is yes and no. She can claim up to 3 years before today. That means by the 2017 September. Okay, any outstanding sum prior to the September 21st, she is not able to claim anymore because no areas of maintenance is recoverable if it accrue more than 3 years. Is under section 98. Okay, and how much is enough for children maintenance? Like I said just now, it goes back to the means and needs test. Okay, some they may not be able to tell you how much they need because sometimes the mother may contribute some if she's working and the husband is paying some. So I think minimum we have I come across will be the parties will apply for 500 for the child if there's one child only, 500 a month. If you ask me, is quite reasonable, yeah. Unless the husband is really the low income earner lah. Okay, next, maintenance of spouse. Okay, the court may also order a man to pay maintenance to his wife or former wife. Okay, the same test applies, the means and needs test. Okay, what is the standard? It would be the lifestyle that the husband used to provide for the wife. Okay, and the degree of responsibility that causes the breakdown of the marriage would mean, let's say if it was the husband who caused, if he committed adultery and caused the breakdown of the marriage until the wife wanted to file divorce, if it's proven in court, then chances are the husband will be ordered to pay what has been claimed by the wife. Okay, for example, previously, if the husband is paying the wife 5,000 a month, okay, then when the wife filed for the divorce, she can actually also claim the 5,000. Okay, and it's proven to court that the husband was the one who caused the breakdown of the marriage. He will have to pay this amount to the wife. Okay, then until when? Okay, for the spousal maintenance, it will be upon his or her death or remarriage. Okay, or if he or she is living in adultery with any other person. Okay, then similarly, for the areas of maintenance, cannot claim if it's more than 3 years. Okay, there is this monthly versus lump sum maintenance suggestion. Okay, because you may have clients comes and complain and says, what if my husband pay this month and not the other month and the subsequent months, then he pays again, then how? Of course, there is no court order can guarantee the payment. But if you have a court order, then it is easier for you to enforce. Okay, and if a client has this concern of the breach of the maintenance order by the court, by the husband, then you may suggest to your client, she can actually pray for lump sum payment, maintenance to be paid by the husband to her. Okay, how much would really depend on what she wants. Okay, then the court has the corresponding power to order a man to pay maintenance to her husband or former husband if the husband is incapacitated wholly or partially from earning a livelihood or by reason of mental or physical injury or ill health. That means the husband is a handicapped person. Then the wife may be ordered to pay maintenance to the husband. Okay, and of course the court will consider first the wife's means and whether it's reasonable to pay. Okay, for example, whether the breakdown of the marriage is caused by the husband, then there may not be such a maintenance order against him, order against her, sorry. Okay, you can see section 77, 78, 81, and 82. Okay. So far, any question? If no, then I will continue. You ask during Q&A also can. Okay. Okay, division of matrimonial assets. What is matrimonial assets? Okay, section 76 provides the how the court will divide the assets that owned by the parties in the marriage. Assets which are acquired by the parties or by either party, such as immovable property such as houses, okay, cars, businesses, EPF, shares, savings, or cash. Okay, the court may order division of any assets or sale and division of the proceeds of sale of any assets acquired by the parties. Now there is no more difference of for the division of the matrimonial assets, whether it's actually solely or jointly acquired by the parties. Okay, because previously acquisition by sole effort of one party, that means if the property is owned or purchased by the husband usually, then the husband will get a greater share. But now that is no longer the law. Okay, and if the asset owned before the marriage by one party, which have been substantially improved during the marriage by the other party or by their joint efforts, the court can also order division. Okay, if there is no substantial improvement by one of the parties, of course, this doesn't apply. Okay, the court wouldn't order any division because that is not a matrimonial asset. Okay, division of matrimonial assets acquired by the parties. You just ignore the joint effort. It shouldn't be a difference anymore. Sorry. Okay, in such cases, the court shall incline towards equality of division subject to the following considerations. Okay, the extent of the contributions made by each party in money, property, or work towards the acquiring of the assets. Okay, that means who pay for the down payment and who actually contributed towards the installment, the monthly installment to bank will also be considered. Then the extent of the contributions by one of the parties to look after the home and also caring for the family will also be considered by the court. Okay, any debts owing by either party which were contracted for their joint benefit, like the housing loan, yeah, then the court will also take that into account. Then the needs of the minor children, if any, of the marriage will also be considered. Okay, then the needs of the minor children will actually refer to a kid if staying with the one who petitioned for divorce, and the husband may come and counter to say the house should be sold because he's the one paying. But the court may actually consider the assistance of these minor children and he needs a home to stay with. May not order the house to be sold or to be disposed of. Okay, the duration of the marriage, previously there is no such factor. Okay, this is new since December 2018. So the longer you are married to your spouse, especially the wife, and she is not working, stand a better chance to get more shares in the division of the matrimonial asset. Okay, then injunction against molestation versus domestic violence. Okay, there is this section 103 of the LRA provides protection for a spouse who is suffering molestation committed by the other party. Okay. Okay. If the client doesn't intend to file divorce yet, but she has suffered the domestic violence from the husband, then you can actually immediately advise her to get the protection order under Domestic Violence Act 1994. Okay, she will have to go to the welfare department and get the emergency protection order. Then after the EMO, emergency protection, or EPO, sorry, the emergency protection order, after that order lapse, then the client, she, the wife, must immediately go to apply for the interim protection order from the magistrate court through the police. Okay, how long would you obtain a court order for divorce? Okay, for joint petition, depends on where you file your case. In KL, previously it was quite prompt. Okay, it takes around 4 to 6 months to get a decree nisi absolute from the date of filing. Okay, now due to the COVID-19, it is definitely longer. Recently, I think we filed the JP in August. We get the date in January in KL. Okay, and for single petition, depending on whether the other spouse challenged the petition, if he or she does not, then it takes around 6 to 9 months to get a DNA, which is the decree nisi absolute. Yeah. If your spouse challenged the single petition, then it depends on the complexity of the matter. It means what are the issues in the petition. It may take 1 to 3 years. Okay, because there is this requirement to exhaust with pleadings. There are more papers to be filed, okay, and to reply and to prepare like bundle of documents if the matter is proceed with trial. Okay, and there is always an option available to call to the parties in court. We call the mediation process. It's always available. Okay, if parties are willing to go for it. Okay, then there is this question: must both parties be present for hearing of their joint divorce petition? I'm talking about the JP, yeah. Okay, answer, it depends on which court you go to. Some court, they actually want both parties to be present. The presence of the two parties are compulsory. Okay, some you can actually apply for the dispensation of the other parties attendance if you can give a good reason. For example, if that party is actually working in overseas, okay, and due to the COVID-19 is quite impractical for that spouse to come back, then you need to prepare an affidavit of non-attendance for her to sign in for example, Australia. Then when she courier back the document, you file in court. Then that affidavit from that spouse, the non-attendance affidavit must explain why that party in Australia cannot come back. Okay, the court will inquire. Okay, don't take it lightly. Okay, don't take it for granted as well, because the court may not grant you and may want the party to come back. Okay, some judges are quite sarcastic. If one party is not present and the reason is not good enough and you are not able to convince the judge actually sometimes may make remark like, when you get yourself registered, yeah, that means register your marriage, why you can come for the registration and why not the divorce. Okay, and may actually adjourn your matter, or worst case scenario, they may actually cancel, strike off your petition for divorce. Okay, these are the procedures between JP and the single unilateral petition if it's uncontested. Okay, for joint petition, there are agreed terms. Okay, to be actually consented between the parties. Then you draw up the terms in the JP for the parties to sign, and they need to affirm certain documents before the commissioner for oath. Then you file in court. Then after that, the court, you will extract the sale JP, the endorsed JP, sorry. The court will give you a date that endorse on the JP, on the front page of the JP. Okay, then you get the date from the JP, you attend. After both parties attend the court, then you file your draft decree I sign. And now KL or Shah Alam, both you need to put in draft decree I sign and also the draft order. Previously, only draft decree I sign will stipulate all the terms once and for all, but now they split it. Okay, reason is because sometimes the parties would like to have their terms remain confidential from the JPN. Okay, because if the decree I sign listed all the terms, then it meant that the terms will also be exposed to third party like in JPN, those officers in JPN. Okay, you file the draft decree I sign and order in court, you will get to extract it from court. The court will comment, then you fair the state documents of decree I sign and order, you file the fair copy, then you extract. Then 3 months later, okay, about it 3 months, if your client asks, are they considered divorced after they attend the court when the decree I sign is pronounced in open court? The answer is no, because and until and unless the decree I sign is made absolute, then only they are considered a divorced spouse. Okay, and normally the period is 3 months. You need to wait for 3 months for the decree I sign to be made absolute. Okay, which you can see number 8 here. 3 months you file the draft decree I sign absolute. Unless party, when they attend court hearing or before they attend, they tell the lawyer they want it to be made absolute immediately. It's possible, but it is up to the court whether they want to grant it immediately or not. Okay, otherwise parties need to wait for 3 months. Then they extract the approved draft from court, then file the fair copy. When they extract, then of course there are some school of thought that says the decree I sign better to be served by lawyer. because JPN will then take notice that the divorce has already taken place between the parties. Then they will update the marriage status of the parties. Okay, but the law actually says it's the court's duty. Okay, so my practice is that I don't help the client to submit to the JPN. Okay, normally I don't, unless when they come back and say there are issues, then I will help them. Okay, to check with the court and also to liaise with the JPN. Otherwise, it should be the court's duty. Okay, because the order comes from court. It's better for the court to inform them, inform JPN to update the marriage status, marital status of the parties. Okay, then come to this single unilateral petition if it's uncontested. Okay, your client will tell you that she is not on talking term with the husband. Okay, or the husband is not on talking term with the wife. Then she will tell you what all she wanted. The custody to be of the children to be given to her, maintenance of how much to be paid by the husband to her. Okay, and she wants some maintenance because she is not working for herself. Okay, she will tell you how much, then you will actually prepare that proposed terms in the single petition. If there are matrimonial assets, she will say that the joint name properties that they used to stay together and now she has moved out, she can actually propose to you and propose to court that the matrimonial asset, that joint name properties is to be disposed of. Then any proceeds from the sale of that property is to be divided equally between her and the husband. Then you get all the terms drawn up and put in the single petition. Then you get the petitioner or your client to sign, and that certain documents need to be affirmed before the commissioner for oath. Okay, after affirmation is done, then you get those papers filed in court. Okay, then you extract. Okay, when you extract this one, the court will actually give you a case management date because it's a single petition, it's not a hearing straight away. Because you need to serve all the divorce petition papers on the respondent husband or respondent wife. Okay, if you're lucky, you can serve personally. Then you file the affidavit of service. Then you go to court, you attend the case management and update the court accordingly. Okay, then the court will actually tell you there are certain deadline for the respondent to revert, to file the notice of intention to defend the single petition, and then that is 8 days after you serve on the respondent wife. Then another 21 days would be will also be given for the respondent to file the answer to petition. Okay, the respondent husband or wife may also have what we call that, cross petition. Yeah, if she is actually challenging the ground of divorce stated by your client. Okay, if those papers are not filed, okay, and deadline have passed, lapsed, then you need to put in this direction for trial into court. The court would actually know that deadline given to the respondent already expired. Okay, then they will give direction and also fix court hearing. Okay, those papers also, there is a notice for trial, which you need to put in court, file in court, then need to be served on the respondent. Okay, notice of trial. Then after you need to serve this, then you attend court. If respondent is not there, you will get the order in terms. That means whatever your client prayed in court, normally you will get that. Okay, you file the draft decree nisi and draft order. Okay, then it will be approved by court. You will extract that approved copy. Then you file the FAIR. Okay, then you file the draft decree nisi absolute after 3 months. Unless it's made immediately, then you can actually file the draft decree nisi, draft order, draft decree nisi absolute together with the notice application for to make decree nisi absolute. Okay, then you extract the FAIR copy. Okay, then it's up to the court already. It's in the court good hands to extend that copy, that orders, that decree 9 not order the decree 9 to the JPN to update the marital status of the parties. Okay, can you claim costs or legal fees against your spouse? In a JP, both parties may agree as to whom shall bear costs and legal fees of filing the divorce petition. Of course, it normally will be the one who wanted the divorce bear the cost, unless the other spouse is kind enough to share the portion. Okay, then the single petition, unilateral petition, the court may order each party to bear their own cost. Okay, because in family cases, there is no winner, only loser. So the court wouldn't grant costs against any party. Okay, unless it is clear and obvious that the spouse has caused the marriage broken down irreparably. Otherwise, the one who filed the petition will pay her own lawyer's fees, and also the respondent will pay his. Oh, I come to the end of the slides. Am I too soon? What time is it now?
Okay, thank you Caroline for the presentation.
No problem.
Okay, now we move to Q&A session. Let us look on the chat box. There are a few questions posted here. Okay, the first question from Kelvin Goh. How long would a joint petition proceeding generally take?
Sorry, again?
How long would a joint petition proceeding generally take?
Nowadays, I think it would be 5 to 9 months, because the long hearing date given by court. Otherwise, previously, it would be 4 to 6 months. You can get the DNA already.
Okay, now we move to next question posted by Kashmir. Okay, for spousal maintenance, can the court order the wife to pay her former husband instead?
Former husband, I would suppose the divorce proceedings has already been over. And in my slide, I share that unless the husband is actually a handicapped person, otherwise there won't be any maintenance order made against the wife. And there are also other considerations that will be considered by the court. It's not automatic. And if you are talking about the after post-divorce proceeding, I doubt so.
Okay, then the last question also posted by Kelvin Goh. Is prenuptial agreement valid in Malaysia?
It's not recognized. Unfortunately, it's not US.
Okay, I believe that's all the questions we have today. Is there anyone who would like to ask any question to Caroline?
Yes, anyone? Sydney, say hello. Hello.
Hello, Caroline.
Hi. I cannot see your face. Hey, Miss Chong.
Hi.
Oh, hi.
Thanks for holding this this webinar.
No problem. My pleasure.
Very informative. I'm sure the lawyers and staff that have learned a lot from today's webinar.
Good.
Yeah. Any questions, colleagues?
If there's anyone who would like to ask
Don't be shy,
questions, please unmute your microphone first.
Caroline, I just want to check with you, right? For Sharia, divorce, civil divorce, what's the difference between civil law divorce and Sharia divorce. I mean, I know that, you know, of course, religious wise is definitely different now. But let's say one is Chinese and one is Malay. So is it definitely have to go to Sharia court?
It depends when their marriage was actually when the conversion took place.
Oh.
If the conversion took place after they get married under the civil law, then either party can actually petition for divorce in civil law, civil court.
Oh,
yeah, previously,
okay.
Previously only the one not converted can actually file divorce in civil court. But under the new law, even the converted party can file the divorce in our normal civil court.
Oh, okay.
Because previously, because they cannot exhaust to their to our civil court, that's why they filed in Sharia court.
Sharia court.
This is why I was made to understand. But now under the new law, I don't think they have excuses to actually only revert to Sharia court. And the court, the section, the provision in the LRA actually provides very clearly our civil court has exclusive jurisdiction to make orders, any ancillary relief order against the non-converted spouse and also the converted spouse.
Okay. Another question is if the spouse, if there's a maintenance order lah, but if the spouse right don't that means don't follow, don't comply lah, what will be the remedies for the other party?
They have filed, if they have filed for divorce, surely they can pray for maintenance to be. It depends on whether your maintenance order is made in the divorce or that what you are referring is the maintenance order already made in a divorce, is it?
Yeah.
Okay.
That means there is already a order granted by the court. Say that every month you have to pay 1,000 maintenance to the wife, let's say. So what if the husband don't pay, the ex-husband don't pay? What can the wife do?
See whether you want him to be put in prison. If yes, if your decree nisi, your court order has the penal notice, I think you can actually cite him for contempt of court because he is
okay.
court order. But if you want the monetary form of the money lah, if you want the money, then you file judgment debtor summons.
Okay.
And also under the maintenance, the Enforcement and Maintenance Act, you the wife can actually go to Sessions Court also and seek for the attachment of the salary order.
Garnish lah. Garnishing lah.
It's like garnish, but we call attachment of salary order lah in Sessions Court. Quite fast.
Okay. Okay. Can. Okay, so far I have no more questions. Any questions? Any other questions?
How about others? Any questions?
Don't be shy.
They are still shy.
Never mind. If there's no questions, okay. We thank you, Caroline.
I don't really like webinar like this, Zoom meeting. You cannot see people's face.
Too shy to on the video. haven't make up yet.
Make up yet? The heavy lunch, is it? All of you?
Haven't make up, I say.
Make up. I also didn't make up.
Okay.
If there are no more questions, Mai?
Okay. So thank you, Caroline, for the very informative session. So before we end the session, kindly be informed that we will send an email with evaluation form. So please submit the feedback. So I believe that's all the time we have today. Thank you, Caroline.
Thank you, everyone.
Thank you. We meet again.
Sure. Bye. Take care.
Bye bye. Take care.
Mm.